Welcome. This is the Domain Name Law Show. We're here every Tuesday, noon Pacific, 3 p.m. Eastern. It's where we talk about domain name legal news and we review recent UDRP decisions. Those are domain disputes. There's three hosts to the show. My name's Todd Ryan. Jeff Neuman and David Michaels are my co-hosts. I'd like to start off by saying hello to those guys. Hey, Jeff, how's everything going with you today? Yeah, we went over one of yours last week. Have a couple questions for it, if you can remember about that Gleamer.us case. But yeah, well, David, how's everything at where you're at? David, what's up? Nice. If anybody wants to check out our outline, you can certainly do that. dnlshow.com/outline. You can see what we're going to cover today. But the very first thing I had on the menu, the menu was questions for Jeff about Gleamer.us case. So I just wanted to say quickly for those who weren't here last week or certainly don't remember, but the domain name was GLEAMER.us. Jeff happened to be the panelist in this case, and it was a case where this company, Gleamer, was a French medical AI imaging company, if you will, was represented by some lawyers, and they filed this UDRP against, well, the respondent, but the respondent in this case ended up being Wild Wild West Domains, which is the GoDaddy reseller, because they had repossessed this name from, I guess, I don't know in what sense they repossessed it, but that's what we'll ask Jeff about. Jeff did eventually rule, and we're not going to go through this case like we did last week, meaning in so much detail, but Jeff did rule that this was a transfer. So for I think for a couple reasons, but Jeff, tell us about why Wild West Domains, which is the GoDaddy reseller, was, as you considered as the panelist, the respondent in this case, and what does that mean by they repossessed it?
The registrar wants to, for some reason, um, uh, wants the wants to take over the account itself as opposed to just the domain name. So let's say Wild West went in and said, "Oh crap, yeah, there is fraud going on here." And wait a minute, there's also fraud going on with all these um, other things. Sometimes registrars will, because there's an investigation or because they want to look at the account as a whole, they'll repossess names. This is not a situation where a name is taken back because of an auction or a name. This was clearly, and with the evidence was provided, this name was being used for some bad stuff. Um, and the FBI was even informed about it. So this was a case where the original registrant, whoever that was, um, registered the name and began using it for bad things. Um, so in the procedural order, I was you don't want to you don't want to punish a registrar for doing the right thing, right? The right thing was stopping the domain from resolving. And in this case, because they were also looking at an account level, you don't want to you don't want to you don't want to punish the registrar, like I said, for doing what it's supposed to do. Now it does it a little bit differently than most other registrars do, but that could be because perhaps law enforcement asked them to do it. Who knows? Um, but at the end of the day, I sent a procedural order basically trying to get them to provide the actual name of the registrant as to who it was before they repossessed it. For whatever reason, Wild West did not respond to my procedural order. And so then I'm back to the beginning going, okay, if I consider Wild West as the registrant, I'm punishing the complainant because the complainant filed a legitimate case against who it thought was the registrant, and it proved its elements if GoDaddy or Wild West wasn't the registrant. If instead of repossessing it, Wild West had just turned off the DNS and left the who is the way it was, this would be an easy slam dunk case for the complainant, right? The complainant was never given any other information as to who the former registrant was. I was never given any information as the former registrant. And if I would have said, well, Wild West is now the registrant and it's being used, and it was, if it was registered or used in bad faith, if I considered Wild West to be the registrant, it's harder to find bad faith because I don't think there was bad faith for the registrar in repossessing the name and not using it. So, in line with other cases, and what I was hoping to get in the response to the procedural order, because it would have provided more backup, was yes, Wild West was not the original registrant, nor should it be considered the registrant now. It's just because it took the name down, listed in the who is as being a new registrant, but there was never a domain transfer. It wasn't as if ownership transferred. And so because of that, I recognized Wild West as being the registrant, the original registrant. Um, sorry, as not being the original registrant, and I basically considered it as if it was still in the hands of the original registrant, and I found that it was registered and used in bad faith. And it was all from a procedural, not a substantive standpoint. And I think this is where David's going to come in. But I ask him to remember this is not on the substance, but on the procedure.
Well, David, before you mention anything, this was a .us, and .us means it's registered in bad faith or used in bad faith. It's not an and. So before David asks his question, I want to ask you, Jeff, real fast. If this was a .com instead of a .us, you said you ruled that as though that original registrant, and you did believe he registered in bad faith and used in bad faith. If this
Yeah,
was a
I wouldn't have
.com,
done this differently.
you
I
would have
would
done
not
it
have done it
different.
differently.
Okay, David, go ahead. I know there's a couple questions you have on this.
Yeah, so you said there was an FBI report in this case. Does it have a date when the report was made? Do you have anything in the complaint that says when Gleamer SAS became aware of the phishing operation?
No, I don't. I don't have that.
Because GoDaddy changed the DNS 8 days after the registration date. And it seems to me that maybe the entire account was fraudulent because the who is for .us is open, right? So the complainant
Yep.
could have seen the who is right away if they had checked in the first 8 days. But because they didn't know who it was. But here's the thing. What if it was a .inc name, or that's a $2,000 a year registration fee, and GoDaddy repossessed it for using a fraudulent name, fraudulent credit card, and they got a chargeback notice, and then all of a sudden they're out this money, so they take back the name and contact the registrar, or the registry I should say, to get a refund on that. But the other scenario is, say the name never changed hands. Say it was I leased the name out to somebody. They made their first payment and then it was charged back and I repossessed the name. I didn't know about their fraud and their phishing operation, but yet the UDRP comes a month or two later saying, hey, there was this phishing and fraud going on. But I wouldn't know if it's in GoDaddy's or Wild West's holding account because they don't forward the notice.
Yeah, that's your issue with GoDaddy and Wild West. It's not an issue for the panelist. The panelist looks and sees was the name registered and used in bad faith. That's it. And then
Yeah,
it's a theoretical risk for those that do lease to own, I think is where you're ending up going on this. But again, I didn't hold that the registrar was liable for, the conduct of the um, domain owner. I just said from a procedural standpoint that the registrar, when it lists itself as the registrant of record and declines to respond to a panel inquiry, you can't use silence as a shield. And so I don't really follow what the issue is there. Like, think about if it was real property, right? If you're a landlord, and if you're a landlord and you are renting out a room, an apartment, let's say, to someone, and in that apartment, um, the tenant does something that he's liable for. Let's say he I don't know, gets someone drunk, and then that person goes out and wrecks a car and ends up hurting someone, right? In a civil case, the landlord can be sued. Now, the landlord, because the person who owns the property will be sued. Now, the landlord's probably going to bring in the tenant into the lawsuit and say, this was the actual person that did it. I shouldn't be responsible. And look, I have a contract that gets me out of it, right? But in the end of the day, absent presenting that to a judge, the landlord's liable.
But that doesn't really answer the question for domains where the registrant is using an assumed name with a stolen credit card. And that's where we have the problem.
But why is that a problem? The
Because
name was registered and used in bad faith. I'm not following.
but it was never paid for, and so the registration was invalid, and that's why it was taken back. But now you're going across registration periods. So had the complaint been filed within the first 7 days while the phishing was going on, I would have no problem with the decision whatsoever, because it's still with the original registrant who was doing the bad things. But once it changed, who is, like you said, there was no transfer, but still there was a who is change. And that's what Wild West does. Whenever they have I bought a name before at GoDaddy auction, and it ended up being the registrar ended up being Wild West. But the thing there was, if you look at the who is record, it doesn't show any changes. It's always been the same, anonymous registrant, and so you couldn't actually see when it changed hands, and that's a common problem.
Yeah, but when you file a UDRP request and you do the verification, you get the actual information. Now here, the actual information that we got was the name of the registrant, which is why which was the name of Wild West, which is why I sent a notice saying, hey, is there someone else behind this that originally registered? But they didn't answer. So I don't understand your point. So all I did, but the effect of my decision was that the trademark owner gets the name and Wild West can't auction it off to someone else. I don't see the bad side of what we did.
It's just because it went across registrants, like 2 different periods.
Yeah, but it wasn't a transfer. There was no transfer.
There was a database change internally.
There was a database change, but there was never a change in ownership. It's different.
Okay.
Because David, think of it this way. I mean, the dynamics of the domain registrar business, the domain industry. So that was a definite Wild West repossess the name. So that's a registrar. That's a reseller, but a registrar repossessing a name. Now it would have been different if this guy, say he was for a year doing some illegal fraudulent things, and then at the last day, he ends up selling it to someone else for $10, and then the name transfers to someone else. And now there's a new owner, and then the complainant files a UDRP, and basically then it's different. Then it's a different set of facts, meaning now it really has been transferred to a new owner that is not using it in bad faith. And then, so Jeff, if there was a case like that where someone was doing something fraudulent, doing something wrong, but then they sold the name, and now there's a complaint that's filed against this new registrant who didn't do anything wrong. They bought the name for just a low price. Then it means it's really a lawsuit for the complainant to go after that prior registrant. It wouldn't be a successful UDRP for them, would it?
No, correct. If there was a separate true owner of the domain, then the complainant would be out of luck. But because here there was not a separate true owner, um, I felt like if I had done the same thing I would do with the true owner, that would punish the complainant who did everything right. It's not. It didn't know. First of all, it didn't even know who Wild West was, the complainant. Second of all, so it didn't know Wild West was anything. Was a registrar? Didn't know. It just saw that there's this bad crap that's still up on the site, or that was up on the site for a long period of time, or whatever period of time, and it looked to the whois, saw the whois, filed the case. Now, again, if it were a real new true owner, then the case would have come out completely different. But because this was a repossession as opposed to a transfer of a name or transfer of ownership, I didn't think that was fair for the complainant.
Yeah, I wonder how long when they repossess a name before they delete it, meaning whether it's a
Well,
registrar.
this is when other people said to me, well, you know, if the registrar repossesses it, do they just count that as an expired name when it expires and then they just make money off of an auction? I don't know. Maybe. But that's not our issue. That's not an issue for the UDRP.
Yeah, I can understand why they wouldn't want to delete it and make it available again, and then somebody could do the same thing, but still, what they sit on these names. But yeah, who knows? I guess what they would do. They probably would try to auction it off, even if it was. I don't know. I don't see many auctions for, like, say somebody lets expire Amazon-login.com. I never. I don't know. I don't see many. I don't know. I guess there's trademark names at auction.
Yeah,
Don't
but this
see
is
them.
different, right? This is a decent, could be a decent name, right? Gleamer. I don't know. It's certainly better than an Amazon-login.
Yeah, there's multiple trademark owners for Gleamer in the U.S. So it's registered in a lot of TLDs. I think it was 80 plus TLDs that it's registered in. So it's a commonly used term for business.
All right, we're gonna get to our news real fast. I wanted to mention, because I see Erwin in the crowd. I did. Yeah, he's still here. If you so next week is HandyCon, okay? Or it's actually this week. It's coming up, but maybe it's starting today. I had some other obligations, so I'm not going to be speaking, but I'm going to try to step in as much as possible. I bring it up because Erwin runs a site, hns.au, and we haven't heard a lot, since with these Web3 spaces. Unstoppable now is, completely over. It seems like over here in the Web 2 space. Is it Web 2 or Web 1? I don't know what we're in. But when it comes to, there was, a lot of talk about Handshake for several years. I still own quite a few names in Handshake. I bring up Erwin's site, hns.au, because the other day I went to it, and I always use that because it's the shortest one, to be able to go to links with relation to Handshake if I'm wanting someone to share, or I'm wanting to share a Handshake document. Because even Jeff, you and I were on a call, and people were bringing up Handshake, trying to compare it to the next round and an extension that's on a blockchain as opposed to an ICANN extension. But I bring that up, that Handshake is still around. There's the HandyCon conference. You can go to handycon.com, or like I mentioned, you can go to hns.au and find appropriate links to see what's going on with Web3 and blockchain domain names. Bring that up because I saw Erwin. Hey, what's up, Erwin? Other thing I wanted to mention is it's really heating up for what we're doing. And I say that's Jeff and I with helping companies apply for a GTLD in ICANN's next round. So if you know of a company or an entity or an individual that plans on applying, well, when I say the time is now, the time was yesterday. It's getting late. April 29th, the application window opens. You guys know today's March 3rd, so it's
It's
really
actually the 30th. It's opening the 30th.
opening the 30th. So obviously less than 2 months, and really there's a lot of preparation that needs to be done. There's no, you've waited long enough if you're a company that plans on applying. But I just say that so be sure to reach out. You can just reach out to us individually, either to me or Jeff, and we'll point you in the right direction. I bring that up because there's something I think more valuable to folks in here, and that is Jeff is offering some escrow services through JJN Solutions. Long story short is a lot of domain brokers and domain investors, when they do big transactions, go through escrow.com, or some of the marketplaces offer escrow services. It's really nice to have an attorney handle the transfer if it's a big transaction. And what I mean by that is escrow.com offers their concierge service, and they also offer a standard service. And you might know their fees. I bring up JJN Solutions, which is Jeff's firm, because now he's offering transfer services, escrow services for your money and for the domain name. It's protecting the seller and the buyer, and the fees are less than what escrow.com is charging. I would say reach out to me or to Jeff if you want to, get a rate card or a one sheet on those services, because that's something new that Jeff's offering, and I thought it was pretty fantastic. The news that I wanted to touch on today was Lambo. Remember this Lambo.com case? This gentleman owned the domain Lambo.com. He was on NamePros a lot. He said, that's my nickname. Lamborghini, the car company, of course, filed a UDRP. They lost the UDRP. The owner of the name, Lambo.com, said, I'm not going to let it in there. I don't think I don't think this was fair that the name was transferred away from me. So filed a lawsuit, and Lamborghini was successful in that lawsuit, meaning the judge ruled, yes, the transfer stands. So Lamborghini gets Lambo.com. And then I think there was even an additional filing, but now it's ended. Lamborghini has Lambo.com, but you go to Lambo.com and it's just, goes nowhere. It's not even forwarded to Lamborghini, which we know as domain investors, it's not uncommon to sell a name or to, have a big company purchase a name from you. In this case, they won it through a UDRP complaint and then legal action, and it's still not resolving. David, I wanted to ask you, nothing to see here. Lambo was just doing, protecting the term Lambo.com. They felt like it was infringing, and probably no intention of ever forwarding it. Or what do you think? Was this all for nothing, or still a good defensive move by Lamborghini?
I think it's the right move. I think it would be impermissible for it to actually start using and monetizing the name, given that they hijacked it through litigation. The name would have stayed with the prior owner had the lawyer argued the case a little bit better, I think. But that's my armchair quarterback type of analysis. So it may not mean anything at all. But I feel like the lawyer, he had admitted something that maybe he shouldn't have admitted, but maybe had no choice. And so he lost the argument, and the appeal was fruitless because of that. But I think it's wrong for complainants to file UDRP complaints just to snag a name so that they can use it. That in itself, I think, is a bad practice. I can see them grabbing names that are causing problems for them and putting into a holding pattern like this. That's fine. No DNS records, a dead name. Okay, so they're not gaining anything from it. There's no ulterior motive. What do you think, Jeff?
if I remember correctly, hold on, Jeff.
Yeah, I mean,
Jeff, I wanted to say,
oh,
if I
sorry.
remember correctly, they let Lambo trademark registration lapse, but they still went after the name. So, what was your comment? Do you think? I mean, not uncommon for them to not do anything with it. If it was your client in Lamborghini,
Yeah, I
you
mean,
won for them. What would you recommend?
no, I mean, I don't think they ever had a plan to use it. I mean, maybe they can work it into something years down the road because obviously big companies take a long time to plan out their marketing campaigns and things. But this was a name that they did not want anyone else to have, and their primary goal from the beginning was to get it for defensive purposes, and that's why they have it. There's no requirement for use. Um, they would rather have control over it than having it used by someone else, and that's their prerogative.
Yep. And they were anyway. So it's in the history books. I think that you're right that they'll probably use it if they're smart. Use it for some marketing in the future. Why not? It's a cool name, and um, I don't think it was. I think there were some defenses for the person. He wasn't really. I don't think. Well, he did have a big price on it, so that's what uh, made the panelist also believe that he was targeting the Lamborghini. Well, anyway, that was just saw some blogs. And I got to shout out domaining.com. Domaining.com, Francois runs this thing. I still use it like I used it 20 years ago or 15 whenever we started it. But that's where I go to domaining.com. Even when I'm looking to see the headlines on Domain Name Wire or Domain Gang, and you'll see, all the blogs from domain investing to DSAD. It's still the same as it's always been. So I just go there, just aggregates, all the blogs that I want to see, and then I can just see the headlines, and I don't have to go to each, individual website. But yeah, domaining.com, what a great tool that is. I mean, if you're in the domain space. The second second article was really a UDRP decision that I saw on Domain Gang. So we're not going to review it in detail like our three cases today, which I think you're going to like. Our three cases today: sunleaf.com, zember.com, and pizzaman.com. But dataverse.com was a UDRP. Microsoft was the complainant, and they lost the case. They have a product that's been out for about 4 or 5 years called Dataverse, and they went after this guy who registered the name or acquired the name. He didn't register it because it's been around for a while, but he acquired the name a year after Microsoft developed or started using Dataverse as a product, after they had a trademark on the term Dataverse, but yet the panelist still felt that they didn't have exclusive rights to the term Dataverse. David, did you take a look at this case? And I mean, it was interesting how the panelists ruled about the term Dataverse and a little bit of the research that he did. What comments do you have on this?
Well, the one quote from the decision I like is, "Poor execution, delayed development are not in themselves evidence of cyber squatting." The guy basically has a one-page website. He's based in Cambridge, Massachusetts, and he offers AI data related services. And that's the same place where Harvard is. And Harvard is actually a trademark owner for the term Dataverse in the United States and a couple other countries. It's interesting that Microsoft does not have a registration in the US for Dataverse. They didn't bother applying for it because they didn't start using it until more recently. Harvard got it more than 20 years ago. And I think that made a difference. So yeah, although Microsoft has registration, say in Mexico or in Europe or elsewhere, it doesn't mean they have worldwide rights to this name Dataverse, which is used by a bunch of different entities out there. So this third-party use really saved this guy.
Jeff, the respondent in this case said there were a lot of senior users to the term Dataverse. Is that a good defense?
I mean, it can be, right? Because you're essentially making the argument that, um, you know, Microsoft can't claim an exclusive right to this, and they can't show targeting, and because there's, all these others, they can't show anything specific. And so it helps in some ways, it hurts in other ways, because you're basically saying, yeah, I know I'm using a mark that belongs to a whole bunch of other people. Yeah, under the UDRP, panelists are not supposed to find generalized targeting, but some panelists still do. I don't like that. I think that's not in line with the UDRP, but some people can hold that against you. One of the things I liked, and I think is the problem, and I've had this conversation more so when I was maintaining companies' portfolios, working for a corporate registrar. But companies that are famous themselves think that every single mark that they have is somehow famous as well, right? So, and I think the decision does this. Decision says, yeah, everyone knows who Microsoft is, but we're not talking about Microsoft. We're talking about Dataverse, and nobody knows who that is. What that is. I shouldn't say nobody. That's not fair. But it's not. Sometimes these big conglomerate companies, even the ones that are famous, like Facebook, when they first adopted Meta, um, they think just because they're a huge company that their famousness of their brand, their house brand, somehow translates to the famousness of every mark that they use, and that's just not the case. So to me, this is sort of, I could see this as a UDRP based on ego as opposed to the policy itself, which big companies often have.
Yeah, Microsoft filed a complaint for it's a trust or some type of fund that they had managed. I thought it was Horizon something, but they did exactly that, Jeff. They filed the complaint to try to get a domain name because they felt like, hey, we have this other product or this other company underneath us, and they act like, hey, we're Microsoft, so people should know that we operate this other entity. And it was they lost that case as well. But and I can't recall the name. It was something we covered over here. But in that
Yeah, and when
case,
we were first talking about the Meta cases too, it was kind of the same way, right? Now Meta basically ended up buying up a lot of people at the very, very beginning, but they were sending cease and desist letters relying on the famousness of Facebook as opposed to Meta at the time. Now Meta's been used so long, not so long, but so much that they can make an argument that it's Meta itself is famous, but they certainly couldn't back then. But they were trying to make that argument.
and all we knew before Facebook did Meta was metadata, meta tags, meta. There was, you know, meta was used, and then as soon as Facebook comes in, they act like, yeah, forget all that stuff. We're the only meta that you know. They were actually, I would say, pretty good at. I owned a bunch of meta names. I let a lot of them go. Sold a bunch in some bulk wholesale thing, but I noticed they did send me some cease and desists on the names that I had registered after their announcement, and I didn't receive any for names I registered before that October. I think it was 21, 22. I can't even recall. But when they made that announcement that they were changing their name to Meta. So I thought, it seemed like they were cognizant of filing UDRPs or sending out cease and desist to companies that had registered names after their announcement. But my defense in that case would be, yeah, I registered 300 or 400 prior to the announcement. So I was registering meta names. It was because of Metaverse, and I thought Meta first names were going to be good. And I see Brewster Rooster here, Web Real Estate. Yeah, I remember sending Bruce, Meta Bruce. We traded something maybe, or he gave me $4 for it, something. But anyway, I thought Meta plus first names were going to be something. Turned out not to be, but I did sell Meta Gus for like $6,500. I sold Meta Share, as in share, but it may have been pronounced Metacher, who knows. But and I sold one other one, Meta something else. It was another name. All right. The cases today, pretty cool. Well, if I look at the outline, I always have it on here, and I already mentioned it. You're going to apply for a GTLD. Just contact Jeff and I. Time's running out. I mean, you really need to jump on this. And it's exciting as heck, especially if you're somebody that's, whether you're a brand, whether you're a community that's going to apply for your GTLD, or whether you're just a person who believes, hey, listen, I think I can get this extension, and I think I can run a registry, and I think I can run a tight ship and make money off this. Like I said, whether you're a brand, a community, or you're an individual, the time is now to get going. So reach out to me or Jeff, and we'll point you in the right direction. The first case today, sunleaf.com. And you domain investors are going to love these cases today for a couple reasons. Well, the main reason is I'm going to give away right now. They're all complaint denies with reverse domain name hijacking. Okay, so it's like telling somebody the end of the movie. The sister killed her. Okay, so sunleaf.com is the first domain name. This domain was registered in 1999. This complainant comes along. They're Sunleaf. Okay, they do business as Sunleaf. The company CH Belt and Associates, but they do business as Sunleaf. They have these frozen food products that they've been doing it since since 2008 when they had their trademark. But as I just mentioned, sunleaf.com was registered in 1999, and the registrants, who are the respondents here, yes, they were the ones who actually registered it, are Carol Lyons and Robert Lyons out of Tennessee. They were operating Sunleaf Nursery. So they did this for up until 2016, and then they closed shop. And then this company, Sunleaf, says, we want the name now. They're, the name's not resolving anywhere, sunleaf.com. It's, if it gets sold to somebody else, that could, basically dilute what we're doing. But I guess really they were upset that they inquired about the name. And I think that was in 2022. And the registrants, the owners of the domain, wanted $25,000 for the name. And I bring that up because any domainer in this space, we own sunleaf.com. We're like, that's $125,000. I mean, domainers would charge a lot. Most of the people I know would charge a lot more. And then in the Pizza Man case we're going to get to later, the complainant in that case could have bought that name for $70,000. Domain investors, we think there's plenty of people in this room who think, oh, that's definitely a six-figure name. I guess the point is these complainants could have purchased these names that they filed complaints on for reasonable amounts. So this person could have bought this for $25,000, didn't like the price, wanted to go ahead and go after them. And in this case, it was Charlie, who we know, was the single member panelist, and he just he threw this thing out from the start. He didn't even look at is this confusingly similar? It doesn't matter to him. This was a 1999 registration, and the registrants, the respondents here were the registrants, so there's no way that this complainant had a chance in hell of winning this. So Charlie ruled, yeah, I'm not even looking at anything else. That was enough for me, this fucking date of this registration. So I'm also ruling RD&H because you complainants had lawyers, and you just abused the system thinking you're going to try to get this instead of paying $25,000. Okay, so I basically said everything about that case. Jeff, what comments do you have? And then David, go ahead after
that. After you gave that all away, yeah, it didn't succeed on any level. So it was just an awful case. And I think this was internal counsel, if I'm not mistaken. So it takes a lot to get a panel to, I can't remember if this one of them was internal counsel. And I think this might have been, but either way, if you're basically just hoping to get a name that of something that was registered and in this case used in good faith for a number of years, you're not going to succeed. It's just plain and simple, and anyone who does any practice of UDRP law is going to know that, and so the RD&H was well deserved.
Yeah, I did leave out the respondent. Didn't even respond here, David. That didn't seem to hurt him, huh?
Not in this case, and it's interesting because the respondent's website speaks for itself. That they had started their business in 1999, they retired in 2015, and they might show up. Maybe it'll show up at your doorstep, Winnebago for a visit. They're based out of Ohio, and this seems to be like a retired couple. So the complainant, by the way, is not actually incorporated as Sunleaf Foods, but they are a big company based in Riverside. They're originally based out of Irvine. It's a big conglomerate, and they rebranded their company as Sunleaf in 2017. It says so on their website. And they think that because they have a trademark and they've rebranded to that name, they're entitled to the name and they're entitled to get it for free as opposed to paying $25,000 for it. And that's nuts because it's somebody else's property and they have to pay up. And it's not like it's unreasonable. Like if they asked for $1 billion, okay, but still it wasn't registered in bad faith. Wasn't used in bad faith. So there's still no UDRP case. And I think that's the case. This is one of those abusive type of complaints that should have been RDNH. I think it was actually, was it?
Yes.
All the ones today were.
Okay. Yeah. So this is one of those kind of cases where, I say there are many UDRP, abusive UDRP complaints out there. And I don't know how many are withdrawn or negotiated, but of the ones that we see and that we discuss in our weekly calls, it seems like there's a lot. And, John Berryhill says, well, it depends what you mean on many. And like, if you look at, it doesn't mean most, but many is a lot because there's 10,000 UDRP complaints a year at least.
Certainly the percentage of Kate, well, maybe not even percent. The actual number of reverse domain name hijackings has gone up in the last year. And when someone does a look back, I'm sure they'll see. But the number of filings have gone up too, and it'll be interesting to see if the percentage of RDNHs has gone up, both with respect to overall cases and percentage of denials. It'll be interesting to see.
And actually, Jeff, I think last year, 2025, there was really like maybe a dozen less cases. And I thought that was unusual. Yeah, so a dozen less cases were filed, but yet, yeah, there were substantially more RDNH. So yeah, the percentage certainly did go up. But yeah, I thought that was weird, and it is a fact. There were, I know, was it 6,850 the year before, and then the last year there was 6,830 or something, but slightly lower. But yeah, the reverse domain name hijackings, and I know I'm off on these numbers, but was like maybe 80 or 100 before. Now it's 150. But anyway, they've certainly went up. In this case, so sunleaf.com was reverse domain name hijacking. With you guys in the crowd, how many, raise your hand if you would price sunleaf.com higher than 25,000. If you own sunleaf.com in your portfolio, would you ask more than 25,000 for it? Raise your hand, or any emoji. I love looking and seeing not one. Okay, so we know they're just not listening, because certainly I know most domain investors would be asking more than 25,000 for sunleaf.com. And the same with the next, this next case, I'm going to go ahead and
I'm seeing one thumbs up and one thumbs
up,
down.
one thumbs down, and I see Brad's clapping. Yeah, so he's saying, yeah. Well, I think most Paul, you don't want to get in Paul's way right now. So this next case, I'm not going to give it away, even though I already gave away the decision. So Sunleaf was pretty simple. Charlie gets this, and he didn't even want to say it's confusingly similar to the. There, Adam saying, yeah, he would price it higher, of course. He didn't even want to. I was saying Charlie didn't even want to look at this first prong. Is it confusingly similar? Okay, maybe it is the same. Here I'm saying no. Since this, the predate, he just didn't like that this was filed, and that's why he said RDNH as well. So this next case, zember.com. The interesting part of this case was Zach Muscovich, friend of the show, ICA General Counsel, was the respondent representative in this case. And since I gave away the first one, I'm going to go to you, Jeff, on zember.com. Remember any of the facts to this case, and tell us a little bit
So
about
what
it.
I remember is so this it was a commercial. The complainant's a commercial real estate, if I remember, a real estate company. I think they formed in 2022, but the domain name was registered in 2010, so over a decade before the complainant even existed. So, um, and then I think, if I remember the facts, there was actually um, one of the officers of the complainant or representative of the complainant was actually negotiating for the domain name back in 2016. So he knew, the complainant knew the domain was taken. Um, and, but I guess they couldn't agree on a price. And so they basically said, well, we couldn't agree on a price. Then he formed this other company, this Zember, and then knowing he couldn't afford the price, he then, filed a UDRP, which is, not an appropriate way to use a UDRP. So, right away, the domain was registered 10 years before the formation of the company, and this is a clear Plan B case where they knew and had started negotiations with the registrant and they couldn't get it. And so this is a pretty easy one as well. Classic Plan B. So RDNH was
Yeah,
found.
they were on Zember Group. I mean, the complainant was on zembergroup.com. They just can't take it, huh? You can see, like in the next case, the Pizza Man case, where they're on Pizza Man Pizzeria, the complainant. They just want the exact match. They don't want that extra word on their domain name, and they end up, enter in some negotiations, can't agree, so they think I'm just going to fucking now file for it. But in this case, Zach was representing the domain owner, and he had, I'm guessing, and I'm just guessing here, in December, they they had told the complainant, you're going to lose if you file a UDRP. And apparently they told him twice. I'm assuming maybe this domain owner, he either told him or he reached out to Zach and said, hey, this person's, bothering me. It looks like they are, think they have legal rights to this. And anyway, they did respond and say, if you file, you're going to lose this. When an attorney or a domain owner does this and responds back to an inquiry, who eventually is the complainant, does that, hold a lot? Believe it's a good strategy? Does that hold a lot of weight with the panelist? And Jeff, you can answer then after that, to say, hey, they did warn you you were going to lose. To me, it's like, well, of course they're going to try to say you're going to lose. So I don't think it should hold much weight, but they did it in this case, and they made it sound as though that warning should have stuck with the complainant. The complainant just overlooked it. David, what do you think?
Well, the complaint didn't say that the name was registered in bad faith specifically, but rather the complaint relies on the response to longstanding sale only and monetizing conduct and asserts that this constitutes bad faith use. Well, no, because Zach responded with that, saying, hey, there's two prior decisions with the same respondent saying, hey, his business model is fair. He develops names and you pay a rental or you buy the name, but his model is development for others, but he owns the name. And so that's good. He also mentioned, of course, that the name was registered long before the domain, so the complaint had a trademark. So I think that the lawyers who filed this complaint really didn't have a leg to stand on. This is an abusive filing. If this was a court filing, it would be a Rule 11 sanctions, because they didn't make a good faith argument as to why the lawyer who had told them before you don't have a case, that they do have a case. Like, no, you didn't articulate anything. You didn't show any case law to support your position. It's just like they just tried, you know what I mean? It's like, oh, hopefully we get Don Osborne and the guy doesn't, defend it. I think that's what the strategy was.
Yeah, and to address your question about whether a warning not to file, um, I think that the function of that warning before someone files a UDRP is basically to the lawyer saying, hey, you need to do some real due diligence here. You know, yes, everyone's going to warn you not to file, but when someone does warn you and you didn't know about that about the reason for that warning, it's a signal as a lawyer to just do a little bit more research as to whether this is something you should file. And so I do think it has an effect. Um, Certainly in court it does, because you can be sanctioned for that. But in a UDRP, it doesn't have much weight, except in the fact of it's a clue to the attorney that wants to file that they should do some diligence.
Yeah, and Jeff, I agree. I mean, it's one thing to say, hey, you don't file, you're going to lose. But when you say, listen, if you file, you're going to see that this domain was registered prior, that you don't have rights to, for this reason. Basically, according to the rules, this would be potentially a reverse domain name hijacking as well, meaning you'll be abusing the system. So, right, just anyone saying, hey, you better not file, you're going to lose. There's more to it than that, meaning they laid out, here's the reasons why you really um, filing this is sort of reckless, abuse of the system. Well, it was ruled that way by the 3-member panel, and that was, yes, this is reverse domain name hijacking. They said in the case that I was looking at their ruling. I had one thing. The facts show that the complainant knew the domain predated its rights and had extensive prior negotiations since 2016. And the respondents' counsel explicitly warned them that the claim would fail, but the complainant filed anyway. So the panel found that the complaint was doomed to failure. Okay, so like we said, that was the second case today, ZEMBER. Zach did a nice job of saying, look, this respondent, this domain owner, he owns names like Mamber, Camber, Kember, Timber, all sorts of things that were similar. And that's always important if you really are a domain investor to show I have in my portfolio similar names. That seems to always help. It's more than just that, but if you are a domain investor, to include similar names to the one that's being disputed is, we see John, we see Jason, Schaefer always, use that when available in their defenses. This next case, Pizza Man, unusual case because the domain, of course, is spelled correctly, PIZZAMAN.com, was registered back in 1998. They say it was registered by a domain investor, SyncPoint, but they didn't mention other names that SyncPoint has had. And then in one instance, it made it sound like they had only registered very few names. But anyway, SyncPoint was the respondent in this case. El Centro Foods was the complainant in this case. The only thing I'll say, and then I'm going to throw this to Jeff, is El Centro Foods has been, operating these pizzerias in California called Pizza Man since the 70s and 80s. So they really are, I would say they have, they do have a trademark, and they had some common law marks to Pizza Man, but it was really more geographic, because there's Pizza Man pizzerias really, all from what I understand, all over the country. But this company, this complainant, has 4 locations. They felt like finally they don't want to use Pizza Man Pizzeria anymore. They still use it, but they wanted pizzaman.com. So after all this time, they filed this UDRP. Tell us why you think they, I don't know, waited this long and filed, Jeff, and then tell us about the decision that I've already leaked.
Yeah, I don't know why they waited so long. Um, I think the and I don't know why they filed this case, to be honest. But because it was because it was only located in California, I don't know how they thought, that they would have these, um, that they would be known outside. I'm trying to look just where the respondent was. Respondent was also United States, but um, in essence, there were a couple things here. One is how generic the term pizza man is, and how you just said that's used all over the country, in different states. It's not quite as used as much as Tony's Pizza, let's say, but certainly, pizza man is a um, common usage, plus also just a descriptive word that people use. But I think so the fact that they thought that they had this, um, nationwide right to or exclusive right to use this, I think was a little, um, egotistical at best, narcissistic. But the other problem in this case that came out was that these guys already tried to purchase Pizza Man from the same respondent, and I think the respondent had asked, this was back in like 2023, so about 2 years before this was filed, 3 years. And the respondent asked for $70,000, and the complainant said, no, we'll just file a UDRP. But of course, the panel denied this on all the elements. I think it was a three-member panel, if I'm not mistaken. No, it was just David Bernstein. Okay, one member. And they found in this case, actually, that the respondent, who was a domain investor, and there was some good language in here that hopefully I can find really quick. But basically, they say that a domain investor, it's a legitimate business, and this respondent had a legitimate right and or interest in the, um, term pizza man and their use of it. And so, yeah, because I think the respondent also had, um, no, the respondent didn't have it. That's what they cited. Sorry, I thought the respondent had a whole bunch of other pizza name domains, but they
Jeff,
didn't.
look through that. I'm going to do the same. We'll throw it to
Okay.
David as we're looking through the because I wanted to also ask the crowd: would you price Pizza Man more than 70,000? Give a thumbs up or a thumbs down. Me, Pizza Man, a very attractive name, but I think well, David, what are your comments on this? Then I'll say why I think they ended up filing after all this time. Go ahead, Dave.
So I can tell you why it was filed recently, because the ownership changed in 2025. In 2021, the trademark was maintained with an excusable non-use filing because, hey, we can't follow our between fifth and sixth year Section 8 because, oh, we have this COVID thing and the state is shut down. So, but this was filed in 2021, which is way long after COVID shut things down. But I think that probably decimated the business quite a bit. So in 2025, the business was sold to a new, younger guy who took it over, and he's more aggressive. And he decided he's going to go for the UDRP instead of paying $70,000 for this name. But he also relied on this generalized offer to sell. And David Bernstein says that that's not evidence of bad faith. And this includes generalized offers to sell, including those on third-party platforms. Mere offers to sell for profit, where this does not target a trademark owner, would not be considered to violate paragraph 4BI. And I like that David Bernstein actually wrote this. Now, he's no longer at a big firm, I understand. I think he's solo all of a sudden, and he's giving a more balanced answer here, and this is a really good decision. I like that. Yeah, there's over 200 companies in the U.S. that use the term pizza man, their corporate names, according to Open Corporates. So, and there's even a movie called Pizza Man, and it was like a superhero kid who ate a tomato that changed his DNA, and he became impervious to injury. So it was a comical movie.
Yeah, sounds like something I'd write. I did write a movie way back in the day called The Bone, and it was basically the only thing that was natural on the person was their bones, because they had taken so many drugs, because their parents were scientists, and their parents would give them like lotion that would make them bulletproof, and then eye
Is
drops
this
that
a
could make them see.
biographical sketch?
Yeah, interesting. But well, Jeff, did you see? This has some interesting points to the case. Did you find out what you were looking for? And then I was going to
Yeah,
mention.
I think David actually read it. They also say, because that was in the bad faith section, but in legitimate rights, the panel finds that before notice to the respondent of the dispute, the respondent used a domain name in connection with a bona fide offering of goods and services, and therefore has rights or legitimate interest in the domain name. So, it's always good to find cases where domain investors where domain investment and the sale of domains are a legitimate um, bona fide use of domains, especially where it's found um, where they did not target the complainant or use the goodwill of the complainant or interact with the complainant or anything like that. So it's a good case to hold on to if you're a domain investor.
Yeah, I noticed that Adam said no, he wouldn't charge. He thought 70K maybe was a little high. King and Media Wiz both had thumbs up, meaning they'd price it higher than 70,000. I think David was right on that. By the way, if you would price higher than 70 or higher, put a thumbs up. If you think there was price too high at 70, put a thumbs down. Just curious to see. But yeah, so this new owner of Pizza Man, I'm assuming, David, that these lawyers out of LA, these were litigation lawyers, he probably using them for some other stuff, I'm guessing, and this is just a guess. So he's probably thinking these are their lawyers at Pizza Man, and he probably said when he took ownership, was like, I'd love to get this domain because I want to be on Pizza Man, and he was talking with his lawyers about it, and they don't know much probably about domain law, and they said, well, since this person has always had it parked, because that was one of the comments that the complainants put in there, and that was, this name has always been parked, and the guy's not known by Pizza Man, and you did have a trademark before he registered the name, even though it's been 20, almost 30 years since he's had the name. So lawyers would think, geez, we are checking some of the boxes here. You had a trademark before they registered it. He's never used it in a legitimate way, that's what they're thinking. It's been parked. Um, he's not known by the name Pizza Man, this owner. And there was one other thing that I thought would be interesting. I can't remember it now. But anyway, the panelist, David Bernstein, did rule correctly that you don't have to be known by the domain name if you're a domain investor. And you don't have to do something with it in that industry. You don't have to create a pizza shop just because you own pizzaman.com. And I know what it was. The complainants also said, the complainants lawyers said, and if we don't get this name, it could go to somebody else, and then that would really be confusing and take away from our business. But anyway, like I said, David Bernstein slowed this thing down and ruled correctly. I will say that respondent, boy, they really took a chance of going with a single member panelist, especially for such a valuable name. So we see Zach in the previous case, and Zember, I'm sure it was his recommendation to his client, let's get a 3-member panel here with Pizza Man. Yeah, it looked like the respondent did answer for themselves. They did a pretty good job. I think also just the panelists knowing this guy registered this name 30 years ago. This trademark owner is only in California. Pizza Man is used a lot. And I think David, now we're seeing panelists, even the slickest ones, and David Bernstein been around forever, do a little bit more research than, some do more than others. I know Charlie, in the very first case, he says he tries not to do much. He wants the evidence to speak for itself. And David, I notice you do a lot of research on some of the cases. And then, of course, if a panelist did as much research as you did, then sometimes they would have other questions, or maybe not change their decisions, could change their decision, but realize maybe this is a case more for court, um, a trademark issue than a cyber squatting issue. But most panelists feel like they don't want to do too much research, because then, as they say, then that puts a finger on the scale of one side or the other. You really just want to wait, see what evidence is submitted, and then do research to maybe verify that evidence, but not go out there. But then again, these last couple of weeks, we've seen panelists do some research and basically like, hey, yeah, matter of fact, we did some research and we see there's plenty of other users of this type of mark, basically helping out the respondent. So panelists really, supposed to stay neutral, not try to help one side or the other, by strengthening their case through research. All right. Well, any final comments?
I think that a couple of things. I think it's actually up to the judge to actually do some in-depth, well, not even just cursory research, stuff that takes me 5 minutes or less. They should do that, because just if David Bernstein Googled Pizza Man from Pennsylvania or wherever he happens to be these days, he would have seen right there, like, oh, there's a local pizza place called Pizza Man, and that's enough for him, right? And I think that there is a duty to do some background research, because this is not a court proceeding. It's not really adversarial in the way that, you're hiring, lawyers who are specialized in this area to defend you. SingPoint normally used to hire an attorney, but now the owner is not. He's trying to do it on his own. He could have done a better job on it. He shouldn't have questioned the registration. He should just say, okay, yeah, there is a matching trademark. They have standing. But there's all these other companies out there, and that's legitimate interest, because I'm not targeting them. And it's definitely not in 1998. So like when I lived in Irvine, where this owner of SingPoint lives, in the 90s, I didn't hear about Pizza Man. Maybe you did, because they had a location in Redondo Beach. I've been to Redondo Beach a lot, but I never paid attention to pizza places, so I didn't know about it. But I don't think the owner of SingPoint would have known about Pizza Man, specifically like this complainant, back in 1998. It's just not a famous thing. And it's interesting, the company's called El Centro, but El Centro is on the border of Mexico. Nothing to do with Los Angeles, but all their locations are in the Los Angeles area.
Yeah, I was just talking to my
and this
wife.
law firm?
Yeah, go ahead.
Yeah.
No, I was saying,
This
talking to my
law
wife,
firm,
Pizza
that
Man
filed this?
Dan is up here. Sorry to interrupt you, David. And Pizza Man, yeah, I was in Redondo. I was surprised when they said they only own 4 locations, because Pizza Man, I saw it all the time. Pizza Man, I thought, and then up in the Valley, and then up here, I still hear about it in Ventura County. So I'm like, yeah, I thought they had a ton of locations. 4, not a lot. Go ahead.
So the law firm that represented the complainant actually says on their website that we handle federal litigation involving trademark and copyright infringement, dilution, misappropriation of trade secrets, and other IP issues. We are also experienced in WIPO actions. So it seems like they're claiming they have some sort of expertise in UDRP cases.
Yeah, I wasn't going to mention it one more time, but I'll do it. But you can mostly going to check out my post, because I'm going to start bringing it up more. Jeff's firm at JJN Solutions, if it's domain disputes, IP issues, that's intellectual property, or even entertainment law, that's the 3 areas that you can reach out to JJN Solutions and get some help. When you're in a domain dispute, you need a domain lawyer, and we know several in this space. But the point is, these lawyers, it's a big firm that was representing complainant and Pizza Man, did not only a terrible job, should have told his client, listen, there's reasons why you don't want to pursue this. But I'm sure the lawyers thought, we're going to make a few bucks, and it's only going to cost you $1,500, and then it worked out for them, or not worked out that there wasn't a 3-member panel, that they had to even come up with more money. So I'm sure this new owner of Pizza Man thought, even if they said don't do it, he said, I'll take the shot for $1,500. We're seeing this more and more. But the point is, if you're in a domain dispute, whether you're a complainant, whether you're the domain owner, you need a lawyer that understands domain name law. And then if it's a real valuable name, right, if things don't go your way in a UDRP, you are going to want to go to federal court. You're going to want to be, party to an ACPA action if your name is really worth, quite a bit. So you just want to be prepared from the start to use other lawyers. But SyncPoint, the company you're talking about, David, who was the respondent, I think they handled things themselves in this case. So it worked out for the domain owner. In our very first case, at Sunleaf, the people had a great name. They didn't even respond. That mom and pop shop that owned the nursery, they didn't even respond. Curious why? Did they get notice? Why didn't they respond? Because they still won the case, and it was reverse domain name hijacking thanks to Charlie. But yeah, you at least I think always want to respond in the case. Even it just seems to not work out if you don't respond. Much more high likelihood that there's going to be a transfer, even for a name that you have rights to. Whew, boy, that was a lot of talking there. Hey, on Thursday, Josh and I are going to be really covering a lot of topics about domain name investing. A lot of news that I wanted to touch on today, but it's more appropriate for the domain name investing show. So join Josh and I 10 a.m. Pacific, 1 p.m. Eastern on Thursdays for the DNX show. This week, got a big lineup, and I'll be posting it on my timeline. But just wanted to say thanks for being here, Domain Name Law. We do this, of course, every Tuesday, and we'll be here next Tuesday. Until then, enjoy yourself. Have a great rest of the day or rest of the evening, wherever you're at. And if you are listening on replay, thanks. Appreciate you stopping in. Take care.